Hello, welcome to BUA 205, Chapter 5. So today we are going to talk a little bit about the Constitution. This week is Chapters 5 and Chapter 6, so we are a little bit off the order of the book, but just hang tight. We're going to get to all of those chapters. All right, let me get you. All right, so the Constitution. So we hear a lot, especially nowadays, about the Constitution. How important it is. As we mentioned previously, there's a state constitution and then the federal government has a constitution. So, for anyone that really doesn't quite understand the difference, obviously we live in the state of New Jersey, and so we have a state government. It mirrors the type of government you have at the federal level. So our state government has its own Congress. It has the equivalent of the president, which would be the governor, and it has its own judiciary. And then we have the federal government, and the federal government sort of oversees the states. It has its Congress, which we send people to. It has the legislature, which is our Congress. It has the executive branch, which is the president. And then it has the judiciary, which is the Supreme Court and the lower courts underneath of the Supreme Court. The federal government basically kind of is the umbrella of the government, and it can make laws that apply to all of the states. The states are able to give you more rights than the federal government gives you, but they cannot give you less rights than the federal government gives you. And so you'll see that there are lots of times disputes about what rights are given per state, right? So the most recent thing you may have seen is in Texas, where they have made some restrictions on abortion. That will make its way up to the Constitution because the argument will be that it is stricter than what the Constitution requires and the previous case law of Roe v. Wade, right? So that's a law that Texas put on, and the argument's going to be it's more restrictive than the federal law. So state laws can give you more rights, they just can't take away rights from you. So we have our state constitutions, but most of what you hear about is the U.S. Constitution. So obviously that goes back to 1789, and each of the following has to be consistent with the Constitution: all federal and state statutes, which are laws, all ordinances by local municipalities, all administrative laws and decisions, and every court decision in every case, in every jurisdiction, every place. Both the federal government and the 50 state governments have the power to regulate the people who live in their states. So each state, like we talked about, has its own constitution. This is known as federalism. The federal constitution and the state constitutions confer two types of power on their governments. One is express power and one is implied power. Express powers are those specifically stated in the Constitution. So the Constitution grants the federal government the explicit power to raise an army and to impose taxes. An implied power are those that have risen as a result of an interpretation of the express powers. So the federal Constitution gives Congress the implied power to create an agency to explore outer space. Like clearly back in 1789, they weren't contemplating exploring outer space, but that has been implied. Because we had mentioned previously abortion before, the Constitution does not specifically state anywhere that you have the right to have an abortion. It's part of the privacy rights that have come out of the Bill of Rights and the amendments to the rights and are implied through the conduct of the interpretation of the Bill of Rights. Amendments to the Constitution were necessary to change things as the country was growing and evolving. It's been amended 27 times and will probably continue to be amended, but it is an extremely onerous process to amend the Constitution. To amend the Constitution, it has to have a 2/3 vote of Congress, and then it has to be ratified or approved by 3/4 of the 50 states. So Congress has to first approve it, and then it has to be approved by 3/4 of the 50 states. States can also try and initiate an amendment, but it's very difficult. The first 10 amendments are known as the Bill of Rights, which are our fundamental rights. Another concept that exists is called judicial review. Famous case called Marbury versus Madison. So just so you know, and when you see cases like this, Marbury v. Madison, that means that is a legal case where a court has made a decision. Marbury would be the plaintiff, Madison would be the defendant. This was an 1803 case by the U.S. Supreme Court, and it said that the U.S. Supreme Court has the right to on the state courts to enact laws, interpret laws enacted by lower courts, and to render their decisions that the lower laws are unconstitutional. If the court decides a law is unconstitutional, it may be declared invalid. This is the concept known as a judicial review. The federal and state courts have the power to determine whether laws enacted by the legislature or decisions made by lower courts violate the Constitution. If it is, and again, this is going to be made unconstitutional or invalid and will be considered, like we said, judicial review. The doctrine of preemption says that any federal law would preempt or supersede the state law. So if there's a conflict between a federal law and a state law, the federal law is going to win. The Commerce Clause is also part of the Constitution, and that grants Congress the power to regulate commerce among states in order to prevent the restriction of trade. Courts have held that commerce is defined as the movement of persons, goods, or information across state lines. It's one of the most fundamental powers in the Constitution, and there's different ways to view this, and some people think this should be left more to the states, and some people think the federal government should take a greater role in this. The Full Faith and Credit Clause of the Constitution says that full faith and credit shall be given in each state to the public act records and judicial proceedings of other states. So this really gives each state the ability to enforce the judgments awarded by courts in other states. So like, let's say you live in New Jersey and you get a child support judgment against a mom or a dad, and then that person moves out of state. The new state, let's say New York, will have the ability to enforce that judgment, even though it didn't come from their state, because of this full faith and credit clause. So, example of this is a handful of states provide that individuals may make personal use of marijuana while other states ban it. A citizen of a state that allows its use may not possess or use marijuana in a state where it's illegal. So this is an example where the full faith and credit clause doesn't apply, right? You aren't given the benefit of your protection of your state for that. So for example, New Jersey has legalized marijuana. When the dispensaries open up, if you go and grab some marijuana and then you go across the bridge to Philadelphia, and where it is illegal, you will be arrested, okay? Just because it is legal in New Jersey does not mean it's legal in Philadelphia. If you live in New Jersey and you go onto federal property, I can't think of any federal property right off the top of my head, but I'm sure there's some up in North Jersey. But let's say instead it's legal in Pennsylvania, marijuana use, and you went onto Independence Mall, where the Liberty Bell is and Independence Hall is, that's federal land. So even if it was legal to possess marijuana in Pennsylvania, if you are on federal land and it's not legal under the federal government, you can be arrested and charged. The Supremacy Clause of the United States requires state judges to follow the federal law. So federal law, again, like we said, it is precedent and would take effect over any conflict with a state law. Here's a 3-minute guide to your Bill of Rights. Feel free to watch that on your own. So, First Amendment, right? One of the most important amendments we have. There's 4 parts to the First Amendment: the Establishment and Free Exercise Clause, freedom of speech, freedom of the press, and freedom of assembly, freedom of association, which means the right to peacefully assemble. So let's break them down. The First Amendment has the freedom of religion is divided in 2 different pieces: the Establishment Clause and the Free Exercise Clause. So the Establishment Clause makes it unconstitutional for government to recognize a single national religion or to create policies or practices that favor one religion over another. The Free Exercise Clause requires government not to interfere with an individual's practicing the religion of his or her choice. So let's talk about this case, Engel versus Vitale in 1962. In this case, in New York, schools adopted a daily prayer after it was required by state law. Some parents argued that it was a violation of individual rights, but the school board said it wasn't, since students could opt out. So basically, there's a state law that says they have to have prayer in school. Parents are like, I don't like that. And the school says, too bad. If your kid doesn't want to do it, they don't have to. Well, 5 families led by Stephen Engel disagreed and sued on the basis that it violated the religion clause of the First Amendment. The Supreme Court held 6-1, which means 6 people were in favor, 1 person against, that reading an official prayer at school violated the Constitution because it was an establishment of religion. Okay, so the case meant any state enforced prayer or reading of the Bible in a public school would be suspect. It was also a key case showing the enforcement of the separation between church and state. Right, so this is sort of an example this is where it comes from, that you can no longer have prayer in school. Here's another case, McCollum versus Board of Education. The First Amendment, like we said, contains two clauses that provide religious freedom to individual. The Establishment Clause, which prevents the government from establishing a religion, and the Free Exercise Clause, which provides for the freedom of religious thought and action. So in this case, the U.S. Supreme Court was looking at an Illinois law to see if it was an establishment of a religion case, or if it established a religion. So here's the facts. Justice McClellan, son of Vashti McClellan, attended a Champaign, Illinois public school, which had a program that allowed the teaching of religious instruction during school time. A group of religious leaders from the community formed the Campaign Council on Religious Education and got permission from the school board to set up 30 to 45-minute classes, depending on your grade level, to be taught by religious teachers at no expense to the school, but held in school classrooms. So basically, religious teachers were coming in, teaching religion in school for 30 to 45 minutes on school property, but they weren't being paid. Vashti McClellan, who was an atheist, sued in state court, and she testified that her son was bullied for not attending any of the religion classes. The lower level, the trial court, ruled against her, and she lost her appeal in Illinois' appeals court. So she appealed to the U.S. Supreme Court. The court looked at whether the program violated the Establishment Clause of the First Amendment and the Due Process Clause of the 14th Amendment. The court considered if the Establishment Clause prevented a voluntary release time program that provided religious instruction during school time in school facilities. They held that it did. So Justice Black wrote the majority opinion and reasoned that the release time program, school kids released from school for a family or religious purpose, was a clear and improper entanglement of religion. So basically, the kids were getting released from their classes to learn about religion, and they said this is too entangled with religion. The release time programs had become popular in the early 1900s, and because most programs chose time to release kids to their home or their church for religious instruction, they caused no establishment issues. However, because they kept the kids on school grounds during school hours in this case, it was an establishment issue. So that's why this law was found to be unconstitutional. Here's a little bit more recent of a case. A school had a policy to allow students to vote on prayer before sporting events. In 1995, the school district in Santa Fe, which was an overwhelmingly Baptist town outside of Houston, Texas, established a policy that allowed the student body to vote on whether or not they wanted to have an invocation to solemnize sport events. If the vote was affirmative, a second vote would determine which student would give the invocation. The invocation was supposed to be non-sectarian, non-proselytizing, and broadcast over the school's loudspeaker before each football game. The Does, a Catholic and a Mormon family, sued to stop the practice. School officials in Santa Fe argued that there was no official state action because the decision to pray was determined by student elections and because it was a nominated student, not a school-appointed official, giving the prayer. The court ruled that the prayer was considered governmental speech and it was unconstitutional. The key issue was whether the prayer was protected private speech or a state-sponsored religious endorsement. The court held that the student-led prayer was government speech because it took place on school property at a school event over a broadcast on a school-owned speaker that was controlled by school officials to a crowd in a school-owned stadium with school insignias. The election was sponsored by the school and would allow a majority of the student body to subject minority votes views to constitutionally improper messages. Additionally, some students were even required to attend because they were like a player or a cheerleader or a band member. The court applied what was called the coercion test. Under that test, students should not be faced with the choice of not attending or attending and hearing a personally offensive religious ritual. The elections did not relieve the school of their responsibility since the election itself was created by the school, using the student body as the electorate. Religious matters should not be allowed to depend on majoritarian rule. So in this case, a school district was trying to kind of have prayer in school, but they were doing it in sort of a roundabout way, right? And the court said, no, come on. Everything you're doing here is basically school owned. Just because you're letting the kids vote on it doesn't take it away from being a government sponsored event. Remember, your school is a government entity, right? Your school board. So that's why they consider it governmental. And then this is the dissent for that case. So you can read that on your own. So let's talk about another one of the First Amendment rights, your freedom of speech. While individuals have the right to freedom of political or religious speech, this right is guarded when the speech is unpopular, upsetting, ignorant, or even anger-provoking. Speech that is sexist, racist, ageist, or otherwise offensive is also protected. The act of burning an American flag is considered protected speech, and any laws prohibiting it are unconstitutional. So your speech can also be in expressive action. It doesn't have to just be in words. But not all speech is protected under the First Amendment. Any speech that incites imminent danger, involves child pornography, is obscene, threatens physical harm, is defamatory, interferes with trademark, patent, or copyright, or is deceptive advertising is not going to be protected. You can't just say, oh, I have freedom of speech if you do any of these things. It's unconstitutional for governments to pass a law limiting what a journalist could write or say about a political candidate or issue. This is freedom of the press. However, not all laws that pertain to the press are unconstitutional, right? You can tax newspapers, and so there's some ways that you can get around that. The freedom of assembly, you have the right to petition the government to address your grievances peacefully, right? They have the right to limit sometimes where you can protest. So you have to get, permits a lot. That's been upheld as being okay to requiring a permit. Remember, your First Amendment rights, if the government feels that the health, safety, and welfare of the public requires a minimization of these rights, they can do that. And the court will do an analysis to see whether or not the concerns are legitimate. And if the health, welfare, and safety of the public outweighs the restriction that they're imposing upon you, then they're going to be allowed to do that. So the best way to think of that, right? This comes up sort of now with the COVID vaccine. The argument is going to be the argument about requiring people to get vaccinated is that the health and the safety and the welfare of the public outweighs any restriction on a person's individual right. Okay, and that's where the weight is going to come in. And there was a case in the early 1900s about polio, where somebody was actually arrested for failing to get the polio vaccine, and the court came out and said, nope, the law saying this person can get arrested is okay. It's not a restriction on this person's liberty because the needs of the society outweigh the individual's needs, and because the law was there to protect the welfare of society and as a whole, they can put a restriction on your individual right. The Second Amendment. This amendment provides Americans the right to bear arms. It usually means to carry a firearm, but it's not unlimited either, right? There's been many restrictions on the Second Amendment at times. There was a time where you couldn't have certain automated weapons. Convicted criminals may not own guns. Sometimes there's a mental health check required depending where you live. So those are all ways that you can minimize a right because the safety and welfare of the public is outweighed. All right, Fourth Amendment, that's another one you guys hear about. That requires police officers and government officials to have probable cause in order to conduct a personal or property search. Okay, this doesn't apply to private citizens. Same thing with like your First Amendment right. That applies to when there's a government entity. Facebook, Twitter, TikTok, Snapchat, Instagram, those are not governmental entities. You can go on TikTok or Facebook and do something and violate their policies, and you can't claim it's First Amendment right because you have no First Amendment right when you're dealing with a private entity. Okay, so there is no First Amendment right against Facebook or Twitter because they are not a governmental entity. Now, there's some arguments that are being made that they should be considered a government entity, but right now they have not been considered a governmental entity, and so you have no First Amendment rights against anyone, or Second or Fourth or whatever you want to claim against any private entity. All right, so the Fourth Amendment requires probable cause to search, which is defined as a reasonable belief by a prudent law enforcement officer that a suspect has committed is committing or is about to commit a crime, the judge will then issue a warrant giving the officer authority to conduct the search. All other unreasonable searches and seizures are unconstitutional. So if you hold somebody for 48 hours after arrest, that may be considered unconstitutional depending on the situation. Here's an example, Fourth Amendment. Police chief, concerned that police officers were using their text pagers mostly for personal messages, decided to read some of them. The chief discovered most of the messages sent by one of the officers were personal. After learning his messages had been read, the officer sued both the chief and the city, claiming that this action violated the Fourth Amendment. Because the search by the police chief was motivated by a legitimate work-related purpose, and because it was on a city-owned device, the Supreme Court ruled the search to be reasonable. Okay, here's going to be one of the lessons that you need to learn for life. Any computer that is owned by your work, any phone that is owned by your work, meaning they paid for it, you have zero right of privacy on that device. Okay, they can check your phone, they can check your emails, they can check your time. In fact, if they gave you a computer and maybe even a phone, they probably already have software on there that monitors how much time you're spending on things outside of the work you're doing, like Google or Facebook or Twitter or Instagram or TikTok, okay? So you can't come in and say, hey, you weren't allowed to search my phone. They can search your office. They can search anything that is work property. So be very careful about that. Fifth Amendment contains 4 different protections. You've probably heard this one, double jeopardy, right? Which is the right not to be tried twice for the same offense. There are exceptions to this too, and we're going to talk about that when we get to criminal law. The right against self-incrimination, right? Which is the right to refuse to talk to police without an attorney. Due process requires that all persons be granted both procedural and substantive due process. So procedural due process mandates that all persons affected by legal proceeding receive notice of the time and when they're supposed to be there. And substantive due process mandates that government not unreasonably interfere with your liberty and freedoms. Eminent domain permits the government to take private property as long as the owner receives just compensation. So several years ago, they expanded the New Jersey Turnpike. To do that, they had to buy the land that was surrounding them, but they don't buy it the way you and I would go buy land. Like there's not a sale like that. They literally send a notice or file a complaint against the property owner saying, we're taking your land. Here's what we think the value of your land is. And of course, there's a different value put on that land by the property owner. And then there's, discussions about settling and whatever, but they have the right to take that land if they need it. The Eighth Amendment restricts the severity and types of punishment that might be imposed. This is the cruel and unusual punishment portion of the amendments. So a person convicted of robbery can't be sentenced to death. A person convicted of shoplifting cannot be sentenced to death, right? A minor can't be sentenced to life in prison for stealing a car, something minor. Not minor, but not something significantly major. And a person convicted of assault or battery can't be sentenced to death. In the last several years, they've also determined that sentencing juveniles to life in prison was unconstitutional because what somebody does when they're 14 may not, necessarily be who they are when they're 40 or 30 or 80. So any kid that was sentenced to life in prison had their sentences reevaluated based upon the change in the law. So the Eighth Amendment also prevents government from imposing an unjustly harsh fine. So it can overturn a fine, and you have to have bail as well. The 14th Amendment states that it's unconstitutional to deny any citizen due process. This is known as the Equal Protection Clause, that the laws have to treat all people equally, and if they aren't, they're unconstitutional. The state that laws that don't treat all people equally are unconstitutional unless the state can prove that the law passes one of these tests: a rational basis, an intermediate scrutiny, or strict scrutiny. And the level of test depends upon what issue is going on. So the rational basis test is the standard measuring whether the state had a reasonable basis for enacting a particular law. This is usually used if the law places a restriction on economic or property interest, or if there's a discrimination based on something other than race, religion, sex, or national origin. Intermediate scrutiny test is a standard measuring whether a statute is substantially related to an important government interest or objective and is the least option to accomplish that. So there's a substantial government interest and it's doing it in the least restrictive way. This usually is applied if the law discriminates on the basis of commercial speech or sex. The one you see the most is the strict scrutiny test, right? So when a state wants to make a restriction on something that's a constitutional right, they have to prove that the state had a compelling interest for enacting a particular lawsuit, and there was really no other option. This applies to free speech, press, religion, and most fundamental constitutional rights. 1967, you may have heard of this case. There was a movie that came out a few years ago called Loving versus Virginia. In this case, Mildred Jeter was a Black woman and Richard Loving was a white man. They were from Virginia and they wanted to get married. But in Virginia, interracial marriage was illegal. So in 1958, they went to D.C. and they got married. On their return, they were charged with breaking the law and sentenced to a year in prison. A judge suspended their sentence as long as they didn't return to the state for 25 years. So he basically said, I'm not going to put you in jail if you go move out of Virginia for 25 years. Loving then wrote to the Attorney General, who was Robert Kennedy, John Kennedy, JFK's brother, and asked for his help, and he sent him to the ACLU. The ACLU sued, and in a unanimous decision, meaning everyone on the Supreme Court voted the same way, held that under the 14th Amendment, that law was unconstitutional. So the freedom to marry or not marry a person of another race resides with the individual and can't be infringed by the state. This was a huge case for laws that were banning interracial marriages, and which existed back then in 16 states. And it was later the same types of cases that were relied upon to allow for same-sex marriages. So when the laws against same-sex marriages existed, they made the same argument and ultimately won on those cases as well. 16th Amendment grants the federal government the right to impose and collect taxes. I guess, boo, right? We don't want taxes, but this is where that comes from. They enable us to get taxes under this right. Here's another example. The 8th Amendment, while in the custody of the New York Castle Youth Development Center, a 17-year-old suffered a tragic spinal cord injury while attempting to make a tackle during a football game. Following the injury, he sued the Youth Development Center, so it's like a juvenile prison, and several of its staff members claiming his injury resulted from a violation of 8th Amendment rights. The question is whether or not that would be cruel and unusual punishment that he was subjected to while playing football. And here's just a few other examples that are on here if you want to read them later on. It gives you a great overview of some of the cases. So that is your constitutional law. If you have any other questions, please let me know.